Rose at least can hear me. Yes, thank you. Right, let's get going then. This is about Section 20 accommodation, which of course is Section 76 of the Social Services and Wellbeing Wales Act 2014. The two sections are broadly similar. There are some bits where they're not, but I don't think that's going to trouble us today. And I'm just going to be referring to Section 20 as it applies to England. I wasn't proposing to talk for more than about 15-20 minutes because I know it's the end of the day and it's hot. But of course, if anybody has any questions, please feel free to put them in chat as we go along or at the end. The good news is that the law and practice around the use of Section 20 accommodation is largely settled. And we do also have the benefit of the best practice guidance from 2021. That's well worth a read. It's got quite a nice example of a letter to a young person and also a really good template agreement setting out all the things that you need to show that you've considered. So that's well worth a look, although I'm sure everyone's seen that already. So I'm not going to attempt to reinvent the wheel by simply repeating what's in that guidance. What I want to do is highlight what I think are the most serious things that went wrong with Section 20. And I think we saw a glut of cases in about 2014, serious concerns arising around the misuse of Section 20 in public law proceedings. So I think a clearer understanding of what went wrong there will help us understand both the importance of Section 20 and its limitations. So I'm going to start by going back to basics. What does Section 20 actually say? We go to Section 20 of the Children Act. The key provisions for our discussion today are Section 20, subsection 4, and Section 20, subsection 7. Section 20 is a mixture of duties upon the local authority to accommodate and powers, and that's part of why it gets quite complicated. Subsection 4, the local authority may provide accommodation for any child within their area, even though a person who has parental responsibility for him is able to provide him with accommodation if they consider that to do so would safeguard or promote the child's welfare. But then the key point at subsection 7, a local authority may not provide accommodation under this section for any child if any person who has parental responsibility for him and is willing and able to provide accommodation for him or arrange for accommodation to be provided for him objects. And that's the key word, because Section 20 is, of course, entirely voluntary. Parents can remove their children from Section 20 accommodation at any time. They don't have to give notice. There's a clear discussion by Sir James Mumby, as he was, that parents cannot contract out of their statutory right to end this agreement at any time. Of course, if a parent isn't willing to agree a period of notice, then that could be evidence as to their lack possibly of a child-focused approach. But nonetheless, that is their right. And it is the forgetting of that, the overlooking of it, which has caused a significant number of problems in the previous case law. So looking at in its broadest terms, therefore, you've got Section 20 giving the local authority a mixture of powers and duties to accommodate children. And you can see in the language of the statute where it goes between shall, the duty, and may, the power. You have to provide accommodation for a child if they're lost and abandoned, if there's nobody with parental responsibility, or if they are age 16, 17, and a child in need, and their welfare is likely to be seriously prejudiced if they're not accommodated. Every parent who has capacity to make that decision has the right to give consent under Section 20 to have their child accommodated by the local authority. And every local authority has the power to accommodate a child if to do so is consistent with the child's welfare. So the range of circumstances and children who could end up in Section 20 accommodation is extremely wide. As the best practice guidance states, Section 20 is extremely broad in its application, both in terms of the types of family by whom it's used and the wealth of placements to which it applies. Its range covers orphans, abandoned or relinquished babies, unaccompanied refugee children, children with disabilities, adolescents with behavioural problems, and homeless 16 and 17-year-olds. Placements under Section 20 can include short-term respite care, therapeutic placements, residential and assessment units, secure units, homes of family members, mother and baby foster placements, foster care, fostering for adoption, and so on. It's huge. And I'm sure that also contributed to some of the confusion that began to arise around its application. There's no statutory limits on the duration for which a child could be accommodated, but its long-term use, as we shall discuss in child protection cases, is certainly discouraged. And when considering a written agreement, it's a good idea to be thinking about duration timescales. And of course, a child who's been accommodated for longer than 24 hours will become a looked after child and see Section 22 of the Children Act. And of course, looked after status will bring with it certain obligations upon the local authority. If you want to sort of cut to the chase and have only one case that really brings it all together, then we are fortunate or unfortunate to have a Supreme Court decision. Now, we know that things have gone very badly wrong when a matter ends up in the Supreme Court. The case is, of course, Williams and Another and the London Borough of Hackney from 2018. And I think Lady Hale sums up pretty neatly in paragraph 34, where some of the difficulties around Section 20 have arisen. She's talking about the cases which went wrong, saying they illustrate a number of problems around the use of Section 20. For example, separation of a baby from the mother shortly after birth without the police exercising their powers of protection or any kind of court order, where she has not delegated the exercise of her parental responsibility to the local authority, or she's given consent, but in circumstances where it's questionable whether the delegation was truly voluntary. And there's been some pretty nasty cases where quite a lot of pressure has been put on women who've just given birth to agree to Section 20. There can be retention of a child in local authority accommodation after one or both parents have indicated a desire to care for the child or even formally asked for the child's return. There's absolutely no doubt that that is unlawful. That's a serious human rights breach and could carry with it quite serious consequences. Further, Section 20 can lead to a lack of action where the perception is that the parents do not object to the accommodation, even though this means that no constructive planning for the child's future takes place. So Section 20 nicely illustrates the dilemma posed to the local authority, as Lady Hale commented. Something has to be done to look after the child, but there are serious doubts about whether the parent can validly delegate the exercise of her responsibility. Equally, they illustrate the dangers if the local authority proceeds without such delegation or obtains it in circumstances where the parents feel they have little choice. Because obviously Section 20 provides none of the safeguards and protections for both child and parents which attend the compulsory procedures under the Children Act. However, rushing into compulsory procedures when there's still scope for a partnership approach may escalate matters in a way which makes reuniting the family more rather than less difficult. So, pretty much an enormous smorgasbord of potential problems and dilemmas here when you're considering Section 20 in a child protection context. Of course, I appreciate it's a very different experience if you're looking to provide care for children with disabilities, for example. But I think the focus on where it's gone so wrong in being used as a substitute for care proceedings really brings out the important things that you have to consider. The lack of court oversight does give rise to many problems. As I've mentioned, this could be a serious breach of the human rights of the parents and the child, which could lead to damages under the Human Rights Act. Now, that route seems to have been cut off at the knees since it was made clear that we have to proceed under the civil procedure rules, which sends most family lawyers shrieking into the distance. And also it was clarified that the children's guardian may not bring any application on behalf of the child. I think that's expressly prohibited under the statute which brought the CAFCAS into being. So there was a real rush of Human Rights Act damages claimed, which I think have now fizzled out simply because there doesn't seem to be a way for the child to get access to the court, which is actually a shame. But the amounts being awarded in damages were going up and up and up. And I think there was real unease felt by everybody. So you're not just risking, say, potentially satellite litigation for breaching someone's human rights, although I appreciate that's probably less of a practical reality now. But the practical impact on the child is if you've got parents who you've got worries about how they're exercising their parental responsibility, they're not really on the scene. What is happening to that child who is drifting for years under Section 20 accommodation? Who is steering the ship for that child? The high watermark of Section 20 misuse was probably the case in 2018 of Herefordshire Council and AB. This involved two children, CD and GH. They had been in Section 20 accommodation for 8 and 9 years, respectively, from the ages of 8 years and from birth. Now, the court found that the local authority had failed the children very badly, and this was an example of egregious abuse. The judge noticed, in several instances, care proceedings should have been taken, but were not. A particular decision for CD that not issuing proceedings for a care order would make no difference to CD, given that he'd been accommodated for so long, was fundamentally misconceived and fundamentally wrong. For GH, their mother had been sidelined. She was only 14 when she gave birth. And the court found the local authority had failed to consider the impact of her age on her ability to give informed consent to the accommodation of her child. Further, the local authority had refused to return CD to his mother's care when she asked for this to happen, which meant that CD had been retained unlawfully. Now, in this case, the present director of Children's Services chose to attend court in person, was frank and honest about the past failings, and set out the steps taken to remedy these mistakes. And we find that this is the problem with these cases, because little deviations from good practice become solidified, mount up, the situation gets worse and worse until, like an enormous, horrible boil, it bursts. And I think that's definitely what happened with Section 20. So enough of the doom and gloom. What we have to do is focus on, well, how can we make sure those lessons from the past are learnt and that we embed good practice that becomes second nature, and we never find ourselves again in that situation. Again, if you go back to the Supreme Court in Williams, Lady Hale sets it out, I think, quite neatly in the very final paragraph of her judgment. Parents with parental responsibility always have a qualified right to reject and an unqualified right to remove their children at will, subject to any court orders about where the child is to live. Section 20 gives the local authorities no compulsory powers over parents or their children, and it must not be used in such a way as to give the impression that it does. It's obviously good practice in every case that parents should be given clear and accurate information, both orally and in writing, both as to their own rights and as to the responsibilities of the local authority before a child is accommodated under Section 20 or as soon as practicable thereafter. So we need to unpick that in more detail. The key is that parents must give valid consent to Section 20. Their agreement must be real. So what kind of things are you looking at to reassure yourself that this is a genuine, real agreement? The first and obvious thing is that parents have got to understand what's going on. They must have capacity. Now, clearly, under the Mental Health Act, we are to assume that everyone does have capacity. We're to give them whatever help we can to allow them to be capacitous. But obviously, and particularly with newborn babies, it may well be that a mother who's just given birth isn't in the right frame of mind to be able to engage with this discussion. So I don't think there's any doubt that every social worker obtaining a parent's consent is under a personal duty to be satisfied that the person giving consent has the capacity to do so. So you'll have to actively keep the Mental Capacity Act in mind. Ask yourself, how is this person using and weighing the information that I'm giving them? If you've got any doubts that the person has capacity, then stop. Don't keep on trying to obtain consent. Get advice from your manager or your team leader. Obviously, consent can only be valid, not just if you've got capacity, but if you've got the right information. So the requirement is for the parent to have all the relevant information. And I appreciate that that's a pretty movable feast. And indeed, the Supreme Court seemed to be dodging around this point a bit, saying that consent can be real without necessarily having the full information. It is difficult. Obviously, not every I has to be crossed and T got to be jotted. I think what the Supreme Court said, relevant information is primarily going to be information to the parent. You can remove your child at any time. That's the key point. And of course, as with everything that we do, the overarching umbrella consideration is Article 8, and that interference with that has got to be fair and proportionate. I mean, that's really the buzzword, isn't it? Proportionality. And not only do you tell parents they have a right to end the accommodation at any time, they've also got a right to take legal advice and to do that before they give their consent. But interestingly, when we're considering consent, we mustn't overlook the actual language of the statute, because as we looked at section 20, subsection 7, the language is objects. You can't accommodate a child if someone with PR objects to it. Now, in the Williams and Hackney case itself, the parents were actually on bail and they weren't permitted contact with their children at the time all these conversations were going ahead. Therefore, regardless of whether or not they consented to Section 20 accommodation, they couldn't realistically object, which made it lawful. So don't get too hung up on consent. Remember to read that in tandem with the statutory requirement of objection. If you can't object because you're in prison or on bail, then your consent would not be needed to make Section 20 lawful. But in a situation like that, hopefully you would be going to court in any event. Of course, the category of child really matters. The Public Law Working Group suggests that you divide children into various categories from the very, very young to the slightly older, then of course, the post-16. Newborn babies, as I've hinted at, require very particular attention. The accommodation of a newborn or young baby under Section 20 is definitely discouraged. In the case of Coventry City Council in 2012, EWCH 2190, there was discussion of the best practice when you were dealing with babies, because a woman who's just given birth may not be in a fit state to give informed consent. So the questions that the social worker should be asking include, what is the parent's current physical and psychological state? If the parent has a solicitor, have they been encouraged to seek legal advice? Is it necessary for the child's safety for the child to be removed at this time? And if so, would it be fairer for the court to decide whether the child is removed by court order rather than by an agreement? And I have to say, I do struggle to think of cases involving a newborn where you wouldn't be going to court. But I suppose never say never, that the factual circumstances are almost infinite. So it's obviously, you could potentially have quite a lot of work to do to satisfy a court that you had acted lawfully and proportionately. And although there is no statutory requirement to have a written agreement around Section 20, it's really obviously definitely good practice. And the Public Law Working Group, as I've said, has a nice little example of a written agreement, which is set out towards the end of the guidance. It's very clear, bullet points, dealing with all the relevant issues. So I definitely, if you haven't had a look at that, I'm sure most people have, then that I think is a very good example of a template. So however you want to do it, the agreement that you draft should state that the parent can withdraw their consent and remove the child at any time without notice. The agreement's also got to explain that the parent is delegating providing accommodation and care to the local authority. If the parent isn't fluent in English, then of course the written agreement will need to be translated into their first language. The agreement should be signed by an agent of the local authority, the parents, anyone else with PR. And the agreement should set out the frequency of reviews and make it clear that a review will be triggered by any material change in circumstances. And as I said much earlier, there's no statutory duration limits on section 20, but it would be very helpful in the written agreement to show that you were at least thinking about timescales and where this was going. So obviously, if you take all of that on board and in mind, then hopefully what happened in 2018 will never happen again. And hopefully we are in now much more settled and calmer waters when it comes to section 20. So calling this webinar an update was probably not the most accurate of titles. I think we are clear now where we stand, but those who cannot remember history are condemned to repeat it. I don't think we must ever lose sight of how and why section 20 went so badly wrong. And I think it came from a fundamental misunderstanding that section 20 gave the local authority powers which it just didn't have. It's very much part of the collaborative voluntary working and therefore is unlikely to be suitable in child protection cases, but never say never. So I'm sorry about that late and glitchy start. I see we're now up to 37 participants, so some of you made it across. I don't propose to talk any further. As I've said, it's late and it's quite hot, but if anyone's got any questions, I'd be happy to answer them. I see we've got a comment from Judith Masson in the chat about unplanned reunifications. Yes, I agree. There's a lot of research showing that it's very detrimental and can very often fail. And again, that just really underscores the importance of being open, transparent, and collaborative at the very outset and reducing what you can reduce in writing. And that does save a lot of problems down the line. Okay, well, I certainly won't be offended if nobody's got any questions, because as I say, I think it is actually pretty straightforward where we are now, but it never hurts to revisit why things went so badly wrong, as clearly they did for the children in the Herefordshire case. So if nobody has got any questions, then I would say go and have a lovely evening and thank you for turning up. And hopefully you found that of some use despite our glitchy start. But the recording, I understand, will be put on the Chamber's website. So thank you everyone for coming.